Prison failure to protect lawsuits, New York correctional sexual assault. Attorney Andrew M. Stengel. Failure to protect lawsuit in New York. When a prison ignores the risk of peer sexual assault, not all sexual assault in a New York jail or prison comes from staff. Sometimes a fellow inmate causes the harm. Even so, the facility may still bear legal responsibility when supervision and classification fail. A New York sexual assault lawyer who handles institutional cases can show how that duty arises. Institutions must protect people in their custody from known risks of serious harm, including peer assault. A failure to protect lawsuit under federal civil rights law lets a survivor hold the institution accountable. It pairs naturally with direct staff assault lawsuits. Institutional negligence is actionable no matter who physically committed the assault. This post covers the legal duty, deliberate indifference, the evidence, and the police report myth. Most importantly, it shows why moving fast matters. When a New York prison has a duty to protect you from peer sexual assault. Farmer versus Brennan, a Supreme Court decision, sets the rule. Prison officials violate the Eighth Amendment when they show deliberate indifference to a substantial risk of serious harm. That risk includes sexual assault by another incarcerated person. As a result, housing a known sexual predator in general population without safeguards creates a substantial risk. When assault follows, the institution's liability is clear. New York City jails and DOCCS prisons run classification systems built to separate vulnerable people from known aggressors. Failures in classification directly support civil liability. The Prison Rape Elimination Act adds mandated screening, supervision, and reporting that strengthens these lawsuits. Our guide to PREA rights after sexual assault in New York explains those standards. What deliberate indifference looks like. Under Farmer versus Brennan, deliberate indifference means officials knew of the risk and consciously disregarded it. It sits well above ordinary negligence. Officials must have actual awareness of a substantial danger. Evidence of deliberate indifference takes many forms. First, prior written complaints about the assailant matter. Next, denied requests for protective custody add weight. Furthermore, documented conflicts between you and the assailant before the assault carry real power. Finally, internal communications showing staff awareness round out the picture. Facilities with chronic understaffing, broken surveillance, and thin supervision make assault predictable. Patterns of complaints from the same housing unit help establish institutional knowledge. Rikers, DOCCS, prisons, and documented failure to protect histories. Rikers Island has faced extensive failure to protect litigation. Court documents and investigations have repeatedly identified housing units with endemic violence and inadequate supervision. That documented history strengthens individual lawsuits. We cover the jail-specific issues in our Rikers Island Sexual Assault Guide. In addition, DOCCS prisons, including Attica, Auburn, and Elmira, have faced scrutiny over violence prevention failures. PREA audit reports from these facilities may reveal deficiencies in screening, classification, and supervision. For example, audits often document understaffed housing units, broken locks, and unmonitored hallways. Each deficiency feeds directly into a failure to protect lawsuit in New York. Building the evidence for your failure to protect lawsuit. Strong cases come from careful documentation. First, medical records of injuries from the assault are critical. Next, grievance records showing you reported the threat carry particular force. They establish that the institution had specific notice of the danger. In fact, contemporaneous grievances often become the strongest single piece of evidence. Staff reports and incident documentation complete the factual picture. Additionally, witness statements from others who knew of the danger can corroborate your account. An attorney reaches those witnesses with sensitivity to the risks they face when cooperating. Beyond that, classification records and housing assignments matter too. When screening systems break down, dangerous individuals end up near vulnerable ones. The gap between policy and practice forms the heart of the liability argument. You do not need a police report to file a civil lawsuit. Many survivors of pure assault in correctional settings never filed a formal report. Fear, confusion, and mistrust of the institution all play a role. Missing paperwork does not erase your legal rights. We explain the reporting process and its limits in our guide on how to report sexual assault in a New York prison. Courts recognize the psychological barriers to reporting assault behind bars. Expert testimony from trauma psychologists explains why reporting often feels impossible. Therefore, what matters most is the harm you suffered and the institution's duty to prevent it. Enforce your rights with the law firm of Andrew M. Stengel. Even from inside a correctional facility, you keep civil rights the law lets you enforce. At the law firm of Andrew M. Stengel, PC, we handle failure to protect lawsuits and staff assault lawsuits across New York. Our team brings care, discretion, and full understanding of how dangerous stepping forward can feel. Past cases span New York City jails and DOCCS facilities statewide. All cases are handled on a contingency fee basis. You pay nothing unless we recover for you. Contact us for a free, completely confidential consultation. Email info@stengellaw.com. For more information, please visit our website, stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.